Thanks, Steve, for a very charming introduction. I hope you all indeed agree. Also, a hearty word of welcome on my behalf. So nice to see you all, and maybe also thanks to you all for signing up, of course, for this particular module. So my name Henri de Waele, if you want to pronounce it in a typical Dutch fashion, the country of which I hold a passport. I'm mainly a professor at the University of Nijmegen, which is called Radboud University nowadays, but again, in terms of pronunciation, I won't challenge you in any way with regard to Radboud. University of Antwerp, perhaps much more known in Belgium. I hold a part-time position there for European law, and I'm also a senior fellow at the European Law Center at the University of Bonn in Germany. So basically, well, they say bilocation is impossible, but tri-location maybe is feasible, so I try to indeed spend my time between the Netherlands, Germany and Belgium. I previously performed a year in what was then called the Advocacy Academy, run by Stephen Rury in Warsaw for practicing lawyers of top firms there. But amongst other things also I was engaged in an EU module for competition lawyers, which brought me to Münster and Budapest. So there also we had a particular focus on a different area of EU law. Now for this module, in what is now called the Practical Law Academy, we focus in a 4-hour session. I hope you indeed realize what you signed up for, but it's already 4 hours, and then after you go into the weekend, so I don't envy you one bit in that respect. But well, this will at least be a fun start. I hope it will be insightful. I hope it will be exciting while focusing on the preliminary reference procedure, which is part of the whole judicial protection system we have in European Union law. Now, you could blabber about this extensively as an academic and actually spend 4 hours or even twice that amount pointing out all kinds of interesting theoretical aspects, which actually, practically speaking, are of no use whatsoever. But then, well, to the average scholar, they won't mind at all. My intention here is to make it for you the most helpful, to make sure that you can exploit it to your advantage in actual practice. Hence here the subtitle. The idea is here really, we have this particular procedure, whether you're aware of it or not. Some of you might actually already have utilized it before. Many of you might not have yet done so. I think also Finland, in terms of preliminary references, the numbers are not that impressive just now. But actually with earlier modules in Poland, I would dare say, well, after these kind of modules, those numbers go up. Actually, people realize that there is a certain option here, which they might deploy to their advantage. So maybe here, I think also there might be here a certain knowledge, which indeed you might put to good use, apart from the other skills, which you will be further trained on in the days to come. Now, EU law, of course, well, doesn't necessarily need here this particular procedure. I hope many of you are aware of the fact that EU law can be what we call directly effective. So basically all those rules of European law, as you probably heard already at university for some time ago, already since the early 1960s, the doctrine of direct effect is well established. That means basically that provisions you find in the EU treaties, but also provisions you find in EU regulations and in EU directives and EU decisions, even treaties concluded by the European Union with third states, such as Canada, such as Turkey, even those kind of provisions themselves can be deployed, can be relied upon before actual national courts. And in that way, actually, you could say, well, if you can simply make your case, if you can basically submit your arguments before a national court, then this procedure itself would not be necessary as such. But direct effect might not be enough, depending on the judges you find before you. If you are actually litigating, or even if you spend most of your time in office and perhaps don't see that much of courtrooms, then still you might consider maybe in the courtroom there's a need to try to sway the judge and try to also push him in a certain direction, and that this procedure might actually come into view. Now, it might well be that simply direct effect of the rule you are referring to is not enough. You need also further input, and there the court in Luxembourg is there basically to offer further assistance. And well, there particularly, if you're dealing with brand new EU rules, EU law of course is expanding on a weekly or even a daily basis. We have the new copyright directive underway, to mention just one particular facet. If you're engaged in privacy situations, privacy litigation, of course you will know about the GDPR, basically here the general new regulation on data protection. Well, on those kind of new rules, hardly everything is already cleared up altogether. So there again, this procedure, which you find in Article 267 of the Treaty on the Functioning of the European Union, you might actually have to deploy, because, well, if you simply make the argument based on European law, a national court might not buy it, but the judge concerned, he or she might well be willing to then entertain a reference to the court in Luxembourg, and with that ultimately perhaps you can basically here also twist things further to your advantage. So you have this kind of helpline to the court in Luxembourg, which you can use to your advantage. However, as we'll also notice in this session, this procedure comes with certain pros and cons. So of course there will rarely be an advantage without also a corresponding disadvantage. So basically here, also on the basis of some practical instruments, so basically some practical input you will receive, we will further explore today, where perhaps also it's better to refrain from having a reference be made. So that's roughly here a bit of background, also a further raising of awareness. That's one particular objective, but also if you were already aware of the option, then let's look also at strategically what it can mean for you, and particularly for your clients in real life. The session is set up as follows. We will start off with a brief introductory quiz in an attempt to set the scene, but it will also give me an idea of the extent of your background knowledge on the topic. Now, if you brought your smartphone or other devices, then you'll be requested in a moment to actually log in to what we call the Mentimeter website, and then we'll have a very short quiz, and then you can try your hand at actually providing the right answer. I will walk you through, and we'll then also see, well, who's perhaps already perfectly aware of the general procedural background, who perhaps still has a lot of learning ahead of him or her. So that will be happening in a moment from now. Thereafter, I will expand a bit further on the procedural context and the key requirements. So this is the more doctrinal perspective. I will still make it interactive, but there are some main bits which at least you should familiarize yourselves with if you have not yet already done so. And you might still faintly remember in the old days when you were at the university, then there might well have been a course where this was all treated rather extensively, but the farther away that is in time, well then of course probably here the more handy it will be to brush up your knowledge on this particular front. So that will be your second part for today, and thereafter probably it will be time for a short break, where after the break then we look at then those particular strategic reasons you might have to refer, or as said, actually from desisting from making a reference, so actually trying to also to sway a judge that he or she should not be pushing the matter further, and actually he referred the matter to the court in Luxembourg. We have an actual case here which we will proceed from, and apologies for the late night email, but you received the case in your inbox already. Copies are still available here as well. You'll get a bit of reading time after the break as well to brush up further on this, and well, on the basis of those particular facts and the considerations there of the main parties, we'll look at, well, when exactly will it be advantageous, and from which particular perspective perhaps would it be better to say, well, on that certain issue, yes, maybe clarity from Luxembourg would be fine, and on other aspects it might well be that through your national law, actually you would have a preference to keep things here in Finland, in your case. Here the situation, the scenario is based on UK litigation, but I think you can easily transplant a number of the aspects to your domestic setting, and with that I think also here you have some kind of extra, some extra frameworks to also deploy in the near future yourselves. We'll, after that, again have a bit of a break, and then we'll move on a bit and look at particularly here the references made in that fictitious case. Well, here there's a particular dimension to the noble art of posing preliminary questions, that reference needs to be proper. And of course, well, what proper means, well, all kind of different texts are possible there anyway, not just ethically speaking, but also here in terms of the applicable law. We basically here have a number of quality standards which are relevant to frame a good reference here. There are a number of prerequisites which you should be aware of. Here we'll again engage in a bit of a practical exercise. We'll take a bit of critical scrutiny, scrutiny of actually the hypothetical questions included in the materials. So the fictitious case comes with a draft order for reference by the national court. We can try actually ourselves to improve on those questions themselves, again in an attempt to steer judges in the right direction. Ultimately a judge needs to make a reference, but the judge then needs to frame a question properly. It might be in your interest to get the question right, or perhaps even somewhat deviously, it might be in your interest to get the question wrong. So how to there basically tweak the matter in a certain way, well, what kind of parameters you will need to adhere to, that's something which will be part of this little exercise. Now then we'll be approaching already 6 o'clock pretty quickly. I'll give you a number of practical bits of advice in case you actually get involved with reference. That might mean actually that you or a colleague of yours will have to go to Luxembourg itself to there argue your case. Well, there's some minor pointers here which might still already be good to take on board. And lastly, probably at 5 to 6, we will wrap up with a Q&A, so some further questions and answers which can be put to me. But let me emphasize, if anything were to be unclear in the meanwhile, feel free to pop a question, simply raise your hand. I'm happy to rephrase, I'm happy to clarify, I'm happy to repeat. I didn't spend time in the sauna just yet, but well, I might be a bit too fast anyway, so if you have trouble adapting, maybe I'm also accelerating in a certain way, so do tell me to slow down if need be. We will be collectively slowing down, as I said, with a little break, let's say around 3:15, I think roughly, although Steve's introduction took so much time that actually we might need a little delay. We'll simply impose that delay and not take the UK approach and beg for it in Brussels, but we'll get the delay when we want it. 4:30 would be the other break, basically. As I said, also immediately thereafter, you'll get some extra reading time if need be as well. Yeah. Just a small homework question as a proper teacher of the law. Maybe with a show of hands, who had time already to look at the case beforehand? That's a minority, some wavering as well, but well, then at least the extra time will be useful. If everyone had already read it completely, then of course then we could immediately proceed. But this will be good to indeed to have some more reading time. As I said, if you brought your own devices, you might have the file immediately accessible. If not, then basically you have copies on the front table here, which you can pick up during the break at your leisure. Yeah? Is the setup clear enough? Any particular questions or particular requests? No? Okay, well then we can move on. And then, as said, we have a little quiz here, and I hope here that also the ICT infrastructure in this fine country won't disappoint us. Basically, of course, Finland was, well, at least a world leader in mobile phones for a certain while. And well, still today, I think if you are equipped with your own device, then you should be able to get to this particular website, insert the code, and then here we reach, hopefully, an interesting outcome. So, question here in this quiz, we should be up and running now. So, preliminary reference to the CJEU, Court of Justice of the European Union, is a possibility. On your phone you will be able to read the possible answers more clearly. Who can refer? You have options here. All national courts is one possibility. Highest national courts only as an alternative. Administrative and criminal law courts only. Or lastly, only courts against whose decision there's no judicial remedy. Yes, one respondent, so this is looking at nicely. So we're opting for option 1. We'll keep it anonymous for now, but you see here, the more balls we get at one particular answer. This is like the kind of indicative votes they had in the House of Commons already, so you're not bound in any way. You can act like your own little Theresa May if you want to. Like I said, to get an idea of your backgrounds, it's of course very satisfying, very reassuring for me also to see if you all got it right, but if you got it wrong, then not that much of an issue yet. How many participants do we have again in total? 13? 13? Or
30 roundabouts.
Okay.
32.
So we still have about 10 people who can... Anyone here with who doesn't have a device? Because that means of course you can't participate and then you lag behind. Quite well. This way it becomes really seductive to go with the first option. We do have 2 backbenchers preferring to go for option 4. So Jacob Rees-Mogg is still in our midst, you could say.
This is nothing like Brexit because there's a clear majority.
True. Well, can still be maybe tilted by, well, now 6. Well, you're right. It's looking like an open and shut case already. Please don't cheat. Don't look it up on the internet on the fly. We have still 6 people who might be doing some background research, but it should be a rather more spontaneous thing. So, who has not yet voted? A couple. So feel free to do so. If you prefer to desist, then that's also fine. Then we simply take it from here. If you're completing some other work or updating your Facebook status, then hopefully you can quickly switch to this quiz. 25. Interesting. So we have at least one alternative answer. 27. Can be as patient as Jean-Claude Juncker. So 2 more to go. Apologies, this is boring you stiff. If you already voted, then you're sure you have the right answer. 2 more votes. Who has still not yet voted? Or is this everyone? This must be everyone then. Okay. Well, we have a number of dissidents, and maybe to still retain a certain level of anonymity. Of course, here it's as I said, a bit of an open-ended thing anyway. Who would like to clarify if you were in a minority, at least a minority of 3. So there are some people here who go for that particular option and who would perhaps dare to pronounce on whether they think that's the only right answer. So of those 3, who is willing to step into the light and clarify why that's the right answer? About the privacy regulation before, so maybe you prefer to remain indeed strictly in the dark. Who would like to elaborate on the first answer? If you gave the answer all national courts, and if you're pretty convinced that that's the right answer, who can elaborate? Feel free to. What was your preference? Number 3. Okay, interesting. So, and you base that on faint memory of an earlier course. Okay. Yeah. And you still stick with that answer, or in light of this vote?
I will change it.
You will change it. 25 people got it wrong. Okay, that's like the UK referendum of 2016. You might have a majority, but the majority might well be wrong. Who is sure that he or she isn't wrong, and you voted for all national courts? Then, yes, could you tell me what did you base your answer on? Again, your
basically, if all the courts rule on a wrong interpretation, then it's a waste of time. Better to clear it up
upfront, right? Yeah, that could be going all the way through. So of course you might still have wrong answers. You might have no references, but then further down the line, of course, appeals courts would also be able to do so. But at least not only the okay. Other people would like to speak out. Maybe the one person who thought that actually only the highest national courts. So in Finland you have your Supreme Court as well. So then that would be the only one in Finland able to speak out or able to here deploy this particular procedure. That maybe sounds already a bit unlikely, but at least one person thought that was the right answer.
That was my guess.
Yeah?
Yes.
And you base that on a hunch or?
It's a hunch.
Okay. But any practical experience from your side?
No.
No? Okay. So you're not also litigating yourself at the highest courts in this country?
I have been there, but not in the EU cases.
Not in EU cases. Okay. But you were aware then of the option there at least? Perhaps even there the exclusive option to make a reference, but you simply didn't need it.
Yeah, but they are not. I would say that they are not the common questions. So you need to be very, say, in a small area. I mean, when you need to make, you need to ask any questions to CEU.
You as in you as a lawyer or you as the court itself?
I'm an attorney, but I don't take care of that kind of cases, and I don't need to make
Okay.
any.
I see. Other people would like to pronounce on this? Yeah?
Yeah,
It's my understanding that the highest courts are obliged to make a reference in certain conditions, but lower the courts are able to.
Indeed. Yeah. So that is indeed the right answer. So basically, indeed, here, as we will see, for highest courts there can be a certain extra responsibility, but there's a difference here. I hope you spot also between the highest courts in an absolute fashion and those courts against whose decision there's no judicial remedy, because basically, well, you might still have, let's say, an inferior court in a particular type of procedure where there is no room for further appeal, or cassation, as they say in French. So it might well be that in certain cases you can't even reach your national Supreme Court. So there also a lower court will already be your final instance. Well, for final instance courts there's a particular rule, as we will see, but there's a difference here between those two answers. But anyway, well, both are not correct in terms of this particular question. It's not who must submit, but who can submit. And in that sense, indeed, here it's a free-ranging option, where indeed also here in Finland, any national court might make the reference, and there's no limit here to, let's say, the public law realm, not just administrative criminal law courts, as well, all of you are well aware, private law courts might engage in a similar practice. Yeah? Okay, can we move on? Again, apologies if this was already a bit too clear for you anyway. Then we can go to the next question. Again, you will see it also on your device. Here, again, the answers are, well, unless you have very powerful binoculars, the answers are almost illegible here, but on your screen, they should be perfectly fine. Always tricky here, reverse angle, on which matter may a preliminary question not be referred to the court.